And that's kind of an unusual way for it to happen, but it certainly can happen, and it does happen.
Your star witness is dead. He cannot give a rendition of the facts. All right, so we're back. This is week number 2 of the Grand Canyon Law Group podcast. Last week we had a lot of fun talking about the Scott Falater murder. I guess I shouldn't say we had a lot of fun. It was an interesting discussion about a very serious case involving a tragic homicide. Ultimately, as we talked about, Mr. Falater was convicted. But today we're going to shift gears. We're going to talk also about another homicide, but of completely different style. So, Ryan, what's the topic for this week?
So today we're going to talk about the Harold Fish case. And it's a case where, a lot of people might not be familiar with it, but if you're a criminal defense lawyer in Arizona, you're probably familiar with it, at least in passing, and it will ring a bell. But it was a big case, a really important case on some really important issues when it comes to self-defense, specifically in Arizona, and how a jury is instructed on that, how the defense is presented. And ultimately, it was a case where the Court of Appeals looked at it and said, at trial, the guy was convicted, where a lot of people thought maybe he shouldn't have been because of his self-defense claim. Ultimately, his conviction was overturned.
Second Amendment case for folks, too. Local guy, Harold Fish, you'll get into the facts, but essentially used a handgun to engage in what he thought was self-defense. And, we'll follow the story and understand exactly how it all played out. But not a terribly complex set of facts, but it raised huge, complex issues on the appeal. So, dive in, tell us, I guess, Ryan, what are the facts of the State versus Fish? And let's dig into it.
Yeah, and again, just a reminder for anybody that didn't see our first podcast, the way we try to do it is take a look at what the jury saw. What facts did they see? And that's what I'm going to read straight from the Court of Appeals opinion, because this is the facts of the case as far as the jury was concerned. And then we can maybe talk about what they didn't hear and why that was so important in this case and why they didn't hear it. In May 2004, defendant was completing a solo day hike in a remote area of Coconino National Forest near Strawberry when he noticed the victim off to the side of the trail 30 yards ahead of him at the top of a hill or grade, apparently lying on the ground in front of a car. After defendant waved to the victim, 2 of the 3 unleashed medium to large-sized dogs near the victim began to run down the hill at full gallop as if to attack the defendant, barking and growling. Defendant yelled to the victim, a 43-year-old man, to restrain or control the dogs. But the defendant did not recall the victim at that point doing anything, or at least defendant concluded the victim could not control the dogs. Perceiving the victim would be unable to control the dogs, defendant dropped his hiking stick, grabbed his 10mm Kimber semi-automatic handgun, and when the dogs were about 7 feet from him, fired a warning shot into the ground in front of the approaching dogs, dispersing them to the sides of the trail. At this point, the defendant saw the victim halfway down the hill accelerating towards the defendant. The defendant yelled at the victim that he had not hurt the dogs, but the victim continued to come at him with his eyes crossed and looking crazy and enraged, cursing at the defendant and yelling that he was going to hurt the defendant. The defendant, who was pointing the gun at the ground, yelled to the victim to get back and leave the defendant alone. But the victim continued to race toward him, accelerating, yelling profanities and swinging his arms. The defendant thought the victim was going to kill him and had nowhere to run because the dogs were at either side of the trail. At one point, the defendant yelled to the victim to stop or he would shoot. The 2 men continued yelling at each other, with the victim doing this weird kind of punching thing until the victim was about 5 to 8 feet from the defendant, at which point defendant shot the victim 3 times in the chest. Defendant told the investigators the entire incident lasted no more than 3 seconds, or alternatively 5 to 10 seconds. In various statements he made to investigating officers, defendant said the victim yelled something like, "Don't shoot, don't shoot, don't shoot my dogs." At the time of the shooting, defendant did not know the victim, had never met him before, and knew nothing about him. Defendant covered the victim with a tarp and put defendant's backpack under the victim's head. Defendant then walked to nearby Highway 87 where he flagged down a passing motorist who, per defendant's request, contacted emergency personnel. Paramedics arrived and determined the victim was dead. Defendant gave statements to various law enforcement officers who responded to the scene, and he testified in front of the grand jury. At trial, the defendant argued he was acting in self-defense when he shot the victim. Although the defendant did not testify at his trial, his wife and daughter testified, as did numerous character witnesses who offered general opinion as to the victim and the dog's propensity for aggression and violence. In addition, the jury was given portions of defendant's testimony to the grand jury and heard testimony about defendant's statements to police after the shooting. After hearing 15 days of testimony and considering over 145 exhibits, the jury found defendant guilty as charged. The Superior Court sentenced defendant to mitigated term of 10 years imprisonment. This timely appeal followed, and we have jurisdiction.
Wow. That is an intense set of facts, okay? Again, just to recap so we understand exactly what's happening. Number one, Harold Fish and the victim, the decedent, they don't know each other. Fish is out on a day hike up in near Strawberry, Coconino County. He's finishing his hike, it sounds like. He's coming towards, either the end of the trail or a place where victim is up on a higher set of ground, up, on kind of a higher elevated hill. As Fish comes down the trail, the dogs start to charge at him. Fish is armed with a 10-millimeter pistol. It's a Kimber is the brand. It's a 1911 style pistol, large caliber, 10 millimeter. For those who know handguns, I mean, it's a very large caliber gun, self-defense weapon. I think it was loaded with some hollow point rounds, which are designed for lethal use. Okay, Fish fires into the grounds to scare the dogs, doesn't hurt the dogs. At which point, the victim then starts charging towards Fish. Fish tells him to back off. He doesn't. Ultimately, this guy charges towards Fish. Fish shoots him 3 times in the chest, killing him.
He also, I guess by argument, rendered aid. Put his backpack under his head, covers him, and then goes and finds help to call for authorities.
That's right. And super unique. And there's a number of issues here that we need to kind of flesh out a little bit. But a critical fact here was that these two guys didn't know each other. And that's important because as Fish raises the defense of self-defense in trial, I mean, that is how he justifies his actions. He's saying, this guy was attacking me. It was all I could do to raise my weapon against him and shoot him 3 times. We don't know a ton about the victim's background, except that we know he had some type of character for prior violent behavior. Why don't you tell us a little bit about what the jury didn't hear? Let's focus on that for just a second, because we know at trial the jury was told a little bit about the victim's character, meaning he had maybe some anger issues or general sort of angry character. What didn't they hear?
Yeah, and this gets into some fairly complex, I think, analyses that get made by a court on what evidence comes in and why.
Sure.
And one of those is in self-defense, where you talk about, I want to bring up, and so the attorney that Mr. Fish had, very experienced, well-known attorney, excellent attorney, wanted to bring in specific acts that they knew about that the named victim in the case done in the past, even specifically with his dogs. That's all we know. We don't even know what those specific acts are right now, but we know that he wanted to bring in specific acts that would have, in his argument, shown that he was the initial aggressor in this case. The court said, no, we're not going to bring those in. And that's not an outlandish decision by the court. It's kind of the general default many times.
And when you say the court, we're talking about the trial court.
Correct.
Because the Court of Appeals makes a separate ruling on this, and we'll touch on that in just a moment. One thing, though, that I think is important that everybody understands is that nobody else was on the trail. There was no other human being who witnessed this. Now, those dogs, the dogs, I suppose, scattered or whatever, but there was no other person that saw this. And so you have Fish's testimony only to say that victim is acting in this sort of wild, aggressive manner running towards him. Forensic evidence, there wasn't much discussion on, whether there, let's say the footprints or the markings in the trail indicated or didn't indicate that such was the case. We know that there was some testimony about that offered in the trial, but there wasn't a lot of emphasis in it in the record, okay? So that's one important point. Again, Fish is the only witness to this. Now, I want to spend just a minute on one topic that I think is really interesting, and that's Fish testifying at the grand jury, unless you want to go to something different.
Yeah, before that, because the other piece to that his lawyer argued for was to bring in, or what the court actually accepted, the trial court said you can bring in, and you mentioned this, general evidence of not reputation, and saying, so they had to bring in witnesses to say, in very general terms, yes, he's known in the community as somebody who can be violent, especially with his dogs. And so that testimony did come in. But again, what kind of an impact does that have on a jury to say, yes, I've seen this man around town and he has a reputation for sometimes being violent with his dogs, versus I saw him in this specific incident and here's what happened. And so that wasn't allowed to be in a specific act. But when we talked about, just his general reputation for it, that was allowed in at the trial.
Yeah, and I suppose we need to identify more clearly what the state's theory was, right? Because Fish's theory is very clear in the record, and that was that he acted in self-defense because victim is charging at him. The state's theory is that that didn't happen, that the victim was not the initial aggressor, that Fish himself started this and created a situation where he, in fact, murdered victim. Okay? And so it becomes really important who's telling the truth, whose version of events is more accurate. And from a prosecutor perspective, that's kind of a challenging case because your star witness is dead. He cannot give a rendition of the facts. And so the state, through its efforts with its prosecutor, tries to limit what the jury can hear about sort of bad things about the victim, right?
Correct. Yeah. And was successful,
And they were successful. Again, we're not hiding the ball here. Fish was convicted at trial. Now, I want to go back to grand jury. So, we hear these words, you hear the term grand jury or trial jury. There's a difference between those two things. A grand jury is the body of about a dozen people who hear a case from the prosecutor's perspective. It's a presentation that's done in secret. Only the prosecutor is present. The detective is present. And these grand jurors listen to a summary of the testimony to decide whether there's probable cause to indict or to charge somebody with an offense. Now, there is a mechanism where if the grand jury wants to hear from a witness, they can do that. And so Fish's lawyer was smart in that he wanted to get Fish's testimony in front of the grand jury to do what? To possibly prevent an indictment. Because if you have Fish testify in front of the grand jury and they're convinced as to the self-defense angle, then there may not be any charges. They could do what they call a no true bill or turn the case down, not charge Fish, but it didn't work.
Right. And even before that is kind of interesting in this case, right? Where there's different ways for a case to actually get to charging.
That's right.
This was unique where apparently, and I don't have records for this, but as far as other things that I've seen, the investigating officers on scene potentially said to Fish, you didn't do anything wrong. We're not going to charge you with anything.
Right. And you said this in the beginning. I mean, Fish, he rendered aid. I mean, I think that guy probably expired pretty quickly, but put his backpack under his head, covered him up, went to the nearby Highway 87 to get help. was cooperative with police, spoke to police, told them a couple of times exactly what his version of facts were. And it sounds like, again, we don't have clear record of this, but there's at least some speculation that law enforcement wasn't very eager to charge Fish, but instead it was the Coconino County attorney through their prosecutors who wanted to get an indictment. So fast forward to the grand jury, Fish testifies in front of the grand jury. He gave a little bit of background, and the Court of Appeals does touch on this. He talked about his history of growing up with guns, his understanding of firearms, his ability to shoot, and then his fear of injury or danger from this fellow who he ultimately killed. And so he presented that testimony.
Yeah, and that's unique. And like you said, I think it was a smart move by the defense attorney. It's unusual to have your client testify at that point. We don't want to get too far ahead, but eventually that made it so that could come in at trial, those statements. I think that worked for and against him as well. There were some statements maybe that were inconsistent with some of the facts. And I think that's an interesting point, right? Even in a situation where we think the facts are clear, maybe I think I did nothing wrong, it's generally not a good idea to just make statements to the police. And it's, it can be useful for you, but very rarely. If they decide to charge you, any statement that you made can and will be used against you. It will also be compared to any later statement that you make. As human beings, commonly we have inconsistencies in their statements, even if they're innocent. And the prosecutor that goes after you is going to use those as much as they can, and they did in this case.
Yeah, so, Fish gives at least a couple of versions to police, another version to the grand jury, and we don't have the full record there, so we can't say with specificity how they differed. But one thing that you read in the facts is at least the time frame, right? The Court of Appeals says this either occurred in 3 to 5 seconds or maybe 8 to 10 seconds. That clearly was something that Fish was inconsistent about. He may have been inconsistent about other things. And what's really interesting then is he didn't testify at trial. Now, we talked a little bit last week about the Scott Falater killing. Falater did testify, and we spent some time talking about why you may or may not want to have your client testify. But in self-defense cases, it is that is one of the situations where you almost always have your client testify, right?
Right, and that's what I was really surprised to hear that he didn't. And again, easy to second guess any type of defense attorney when you have somebody who's so experienced and so excellent. It's hard for us to look at and say you did it wrong. But the general idea is, in a self-defense case, you really, especially this one where you've got facts that are just from you that a jury might think are self-interest, right? You're just trying to save your own butt, to tell them the story, right? Not just put it in from things you said previously on a piece of paper that they can read, but to hear that defendant say, this is a scary situation. If they can put themselves in the shoes, that's kind of what it does when somebody tells that type of a story, puts them in their shoes and says, yeah, that was a reasonable decision to do what you did.
Right. And I think, again, I agree with you. It's easy to sit back here and armchair quarterback this, right? And say, I would have done this or I would have done that. And yes, the trial jury had testimony from Fish from the grand jury. There was a redacted transcript that was given to the grand jury outlining to the trial jury what he had said in front of the grand jury. His recorded statements to police were also presented. And that's fine, except that I get concerned as a defense lawyer because Fish is a pretty compelling guy, or was. He was a high school teacher, college educated, father of 7 kids, I believe. Nice guy, apparently. I suspect he would have testified in a very compelling way. And sometimes when the testimony is offered like that live, yes, there's going to be inevitable differences between what he says at trial and his former testimony, although I think they probably would have been slight differences, right? I think something was missing. I mean, I just think, man, if Fish would have testified in his own defense, perhaps that verdict would have been different. I don't know. I'm just guessing. Right. That's something that strikes me as, if I was the lawyer, I would have probably done something different.
But who knows, right? Because there's a lot about this case we don't know that Mel McDonald knew. Right. That's the defense attorney that's saying, hey, if I put him on the stand, X, Y, and Z is going to come out, or it's going to look bad to a jury. We don't know those things.
True, except Fish had no prior criminal record, right? It's not like
and that's usually what they come after.
Exactly, and that's what I default to, because many times if my client wants to testify, that person may have prior felonies, and that's one thing that they're going to get impeached with at the outset, right? But Fish didn't have those things. Instead, it was a situation where, McDonald probably knew something or was afraid of something coming out, or something that the prosecution may have tried to cross-examine him with. Who knows? I mean, it's hard because it didn't happen, and so we're left to speculate. In any event, that's a large chunk for me that I think would have been interesting to know if that would have affected the verdict.
Yeah, for sure. And kind of going back to the charging piece of it that might be interesting for people to understand, generally how a serious case is charged is you have the police investigate. It's kind of like the, Law and Order intro. They investigate, they take a look at it and say, yeah, there's enough here. They submit to the county attorney's office. County attorney's office then makes their own determination and says, yes, we have it, or no, we don't. They can even say, go out and get more evidence before you resubmit to me. But that's not what happened here, right? The police said, at least from all indications, we're not going to charge this guy. Prosecutor, on their own accord, took a look at it, reached down, grabbed this case and charged it, even without it being submitted. And that's kind of an unusual way for it to happen, but it certainly can happen, and it does happen that way.
Yeah, and prosecutors, they are law enforcement. They're not police officers, but they are charged with enforcing the law. And so if they see a violation, whether or not police want to submit on it or whatever, they have the authority to do that. Now, they have to filter it through the grand jury, which is what they did here. And ultimately, a grand jury said, despite Fish's testimony. Now, that may undercut what I had said earlier about trial. Maybe the defense lawyer had that in their mind. Well, Fish has already given a statement to the grand jury, and it didn't deter a probable cause finding. Do we want him to testify now for another time and possibly risk other, pitfalls?
Yep.
So Fish ultimately gets convicted. His case, and he gets sentenced to the minimum sentence. Okay, so just for your understanding, in Arizona, second-degree murder carries a mandatory consequence of a minimum of 10 years in prison and a maximum, I think, of 25 years in prison. He got the minimum of 10. Okay. So,
and that's interesting, right? Because a judge took a look at it, the judge who heard the entire trial, and said, I think you deserve the absolute minimum I'm allowed to give you under the law.
And you don't see that all the time. In Arizona, the courts are presumed to give what's the presumptive sentence, which is sort of a middle ground sentence, okay? And then they listen to mitigating factors, which things are in favor of the defense, or aggravating factors, which are factors that favor a higher sentence. Here, the judge balanced those things out and gave Fish the absolute minimum of 10 years, okay? So that, it does show a little bit about who Fish was. Jury found him guilty. A judge can't change that, but a judge can certainly weigh in on sentencing.
Yep. I thought that was an interesting piece.
So on appeal, Fish raises a number of issues. In fact, the Court of Appeals, I think they outlined 20-something issues that he raises on appeal, a pretty big brief to the court trying to say, hey, overturn my conviction. Right?
Yeah, and so let's get into that a little bit. I don't want to get too deep, because I think the court themselves, the Court of Appeals, says defendant raises approximately 23 issues on appeal. In this opinion, we address the several evidentiary issues and jury instructions. So what ultimately was the outcome, and what were the kind of the bases for that outcome?
Yeah, so we can start in reverse. Ultimately, the Court of Appeals reverses this conviction, and they remand this case for a new trial.
Also unusual. Yeah.
Agreed. If you were to do a survey of all of the appellate cases, probably across the nation, but let's say Arizona, more often than not, by a clear majority, cases are affirmed on appeal, meaning whatever the judgment and sentence were, that stays. Here, Fish gets reversed and remanded for a new trial, which means the Court of Appeal says there's enough error here that took place at the trial level that we undo the verdict and we send it back to Coconino County Superior Court for a new trial. Now, even though Fish raised, 23 issues on appeal, 2 were most significant, okay? And it goes to the prior acts of violence committed by the victim, as well as some jury instructions, okay? So previously, when we were laying out the facts, we understood that the trial court allowed in sort of general character testimony about the victim, meaning he had a reputation for occasional violent behavior. But there were specific instances of conduct, and again, we don't know exactly what they were. There's no record of that. But the Court of Appeals, for about 10 pages, and it's interesting, so interesting to see how the Court of Appeals resolved this. So without getting too deep into the rules, basically in the rules of evidence, well, evidence has to be relevant. And then when we get into issues of character evidence, there's special rules that basically say you can't have what's called propensity evidence. So just because somebody acts one way on one occasion doesn't mean that they are going or more likely to act in the same way on a different occasion. In other words, if I'm violent on this circumstance, you can't use that logic of, I'm going to be violent again.
Yeah, and that's interesting, right? Because we have people who get frustrated by that, who we defend, right? And it is a frustrating situation where you say, no, this person attacked me. And in fact, I don't know, I know them, and I know that they attacked my sister, and I know that they attacked my mom and did this on different occasions. Let's tell that to the jury. And generally, no, you cannot tell that to the jury.
That's true. And what makes it especially complex in Fish is, remember, Fish did not know the victim. So Fish is not aware of this guy. Remember, the first time Fish sees him is this guy's running down the hill charging at him. He doesn't know his past. He doesn't know his character. He doesn't know his propensity for violence or lack of propensity for violence.
And that's so interesting because it comes down to, and that's, I guess I'm glad I did a different example that he doesn't do that. Because if you know somebody, you know their violence and you know their history, it goes to whether it was reasonable for you in your head to be worried. But if you don't know that person, you don't know any of that history, then is it reasonable for you? So it kind of, to believe that they're going to be violent other than this immediate behavior that you are watching, right, and experiencing. And so how did the Court of Appeals break that out?
So again, they spent a long time, what I will call doing some sort of legal gymnastics. They lay out the rule and they say, character evidence in terms of reputation and opinion, yes, you can admit that under the rules, but you can't get into specific instances of conduct. And you certainly can't get into specific instances of conduct where the person doesn't know the other guy. Okay. But then, on the next page, 9 pages in, the Court of Appeals says, but in this case, we should allow it.
And the act, it was so bad that we're going to send it back.
Right. And here's why. It goes to the fact that nobody else could testify to this. And meaning there was no witnesses on the trail. And Fish claimed that the other guy, the victim, was the initial aggressor. And so the jury needed to hear, according to the Court of Appeals, that victim had prior instances of violent conduct as a way to decide whether Fish was telling the truth about the other guy being initial aggressor.
Which is fascinating, right? Because it's kind of the reason why they say you can't have character evidence in the first place. It's this big circle, and it's a little bit of, I don't know if this is legal nerdy stuff that people, but it's a really interesting situation. And how much did the Court of Appeals get into the defense's argument that the state opened the door to that information because they said your version of events is not credible and we don't believe it. And so the defense said, well, now I have to use his prior acts to show that it was, this was something that's not just like out of the blue and I'm saying one thing and the jury just has to believe me, but you can also take a look at his prior behavior.
That's right. And you use the term open the door. I think it's helpful to define what that means in a legal perspective. You and I throw around those terms all the time because that's a legal term of art that is used. Essentially, when the court makes a ruling that says this thing or that piece of evidence can't come in, but then when the other side does something to sort of trigger either a level of unfairness or misunderstanding about that thing, we say that the other side opened the door. Judge, they opened the door, which means, hey, you said previously that it can't come in. Well, that door swings wide open now, so it should be able to come in.
Because otherwise, you've given a false impression to the jury.
Yeah. That's right. And so the state, and the court comments on that, the state did open the door to those specific instances of conduct. And in a little footnote in the opinion, the court says we acknowledge this. But yeah, so ultimately the court says, the trial court should have allowed those specific instances of conduct to go towards the credibility, the believability of Fish saying, this guy attacked me first. Okay? Interesting. And again, they spent the better part of the opinion talking about that. But that was one of two issues.
Yeah, the other one was, I think, the vigor issue. I don't know what you think as far as what's lasting and we talked about at the beginning, how this case has affected criminal defense law, basically for self-defense in Arizona. But I think we'll talk about it also in tandem with, it seemed like during the same time these appeals were going on, the legislature in Arizona, maybe spurred by this case, made changes to the law.
Yeah, let's get into the jury instruction issue, though, before we go to the change in the law, because I think we can spend a good chunk of time on that change, because it's monumental. It was a huge shift in Arizona.
That could make a difference between guilt and innocence in a case.
And had that law been different, I'm kind of getting ahead of ourselves, but had that law been different, I don't know that the state could have prevailed.
And I know we're getting way ahead here, but maybe that's why, just so we haven't said this yet, the state didn't retry him. After it got sent back, they said, never mind, we're not going to try this case. And
just kidding.
Let them go. And I think it was because of that change in the law, but who knows?
Right. So the other portion was the jury instruction. Okay. There's too much to talk about in terms of all of the self-defense instructions. But one of the instructions that was given to the jury was, what does it mean to be the initial aggressor?
Let's take a break here and just talk about jury instructions, right? So what happens in a trial is that all the testimony comes to a close, and literally the judge reads these set of instructions on the law to the jury and says, I need you to, the way you make a decision in this case is you apply the facts you heard. You have to decide what you find credible and not credible, and you have to apply it to this law. And they actually give them the information that they have to compare it to. And so people, I think, underappreciate how much of a difference that makes on, there's some quibbling and there's some argument that goes on with the lawyers on what those instructions are going to be, especially in a self-defense case or something like that, specific to the facts of that case.
That's exactly right. And lawyers will battle over what instructions ought to be given to the jury, because depending on how those instructions are worded, it could be the difference between guilty and not guilty. Okay. So I'm going to read specifically from the opinion so that we have a clear, accurate depiction of what was at issue. Defendant also argues that the superior court, that's the trial court, should have given the jury his requested instructions that for the purpose of self-defense, the term of unlawful physical force includes the statutory elements of the crimes of endangerment, threatening, and intimidating or aggravated assault. Instead, the court just gave an instruction on unlawful physical force, but they didn't say what that was. And Fish's point, his lawyer's point, was that, Judge, we need to know, the jury needs to know, what does that mean? Okay, because when we're saying that the victim acted with unlawful physical force, the jury was left to wonder what that was. And in fact, during deliberations, they asked a couple of questions about it. And the judge says, just refer to your instructions. But the instructions were silent as to what unlawful physical force was. So defense wanted the court to say unlawful physical force includes aggravated assault, threatening and intimidating disorderly conduct. So to give the jury a framework for how they could couch or frame victims' actions. And the trial court refused to do that. It said, no, we're just going to use the standard instructions. We're not going to use defense what you're suggesting. And the Court of Appeals found that to be error. Okay, so that combined with the missing specific instances of character conduct said, this is going back to trial.
Yeah. And tell me if I'm jumping ahead, but I think this might be a good time to say, what was going on in the legislature at the time is they actually changed how the law works as to self-defense. And so it actually ended up changing the standard self-defense instruction. And I think it'd be interesting for people to hear, you hear one instruction, then you hear the other. How much of a difference would that make?
So at the time that Fish went to trial, his instruction would have been that a person is justified in using physical force or deadly physical force to the extent to which that type of force is used unlawfully against them. I'm paraphrasing. But that's the basic idea.
And the basic idea is that a reasonable person in their same position would have felt that force was necessary.
Correct. And it becomes a burden on the defense. So the state would prove, we'll say you're the prosecutor. Your duty is to prove the murder, the killing. And then the burden is on me, under the prior law, the defendant, to say, but my killing was justified. I used physical force when it was appropriate, and my actions were in self-defense. Therefore, my actions are justified.
Right. And it was this balancing that the jury had to do, right? Where it said, okay, sure, the state has proven that this person shot this person and they died. Right. That's basically all they had to prove. Then it became the defendant's burden not to prove beyond a reasonable doubt, but to prove at least it's more likely than not that they used physical force appropriately in self-defense.
Yeah, and it almost flies in the face a little bit of the presumption of innocence.
I think that's a huge piece of it.
Because all of us under the American system of jurisprudence are presumed to be not guilty, innocent, until proven guilty beyond a reasonable doubt. And with self-defense, at least the prior version of self-defense, it kind of shifted that burden a little bit. Yeah, the state had to prove a killing, but many times in a self-defense case, almost every time, it's not in dispute that the person, took whatever action to either kill or hurt or do whatever, but they did so in a way that was justified. They're not saying I didn't do it. They're saying I did it, but the law allows me to do it because I was acting either in self-defense, defense of another person, so forth.
Yeah, and it became a very difficult burden to meet at times. And this is a great example of this case of that, to say a lot of people would hear these facts and say, yeah, if that's not justified in defending yourself, I'm not sure what is.
Yeah, I mean, if it's me on the trail and I've got these dogs and this crazy guy chasing after me, can I do something about it? I think people hear those facts and say, sure. And so that's why I think it was a little bit surprising that Fish gets convicted.
And then we go back and people don't realize, I think what happened was the burden was wrong.
Right?
And,
so in April of 2006, we'll roll back the clock. This is 2 years after the facts of Fish happened, because I believe that was 2004, correct?
Yep.
April of 2006, the legislature amends a statute, ARS 13205, okay? And what that does is it shifts the burden back to the prosecutor, okay? It says justification defenses under Chapter 4 of this title, Chapter 4 of the justification defenses that include self-defense, are not affirmative defenses. Justification defenses describe conduct that, if not justified, would constitute an offense, but if justified, does not constitute criminal or wrongful conduct, meaning if you commit the act and you're justified, it's not a crime. If evidence of justification pursuant to Chapter 4 of this title is presented by the defendant, in other words, defense has to come forward with some proof of self-defense, the state then must prove beyond a reasonable doubt that the defendant did not act with justification.
It's a massive
So it
difference.
flips the script and it says, prosecutor, you now have to prove a negative. You have to show that Fish didn't act in self-defense.
Or that he acted unreasonably in that situation, or...
Yeah. I mean, go ahead.
So effectively, what it does is it changes the instruction, right? So not the way that the defense actually was challenging it, which is interesting.
Totally different instruction.
So it changes the instruction. Instead of saying, using self-defense, now it's your duty, as the defendant to prove it by a preponderance of the evidence that you did use self-defense, right? So the instruction still says, you can use self-defense, but then it afterwards, so that the instruction is actually identical, the initial part of it, but then at the end of it, it says the burden is always on the prosecution to prove that the defendant did not act in self-defense. And it opens this whole discussion on how important presumptions are, and again, that's a legal term of art, and how important the burden is in a case.
Yeah, and it's interesting because how do you prove a negative, right? There's always a subject of debate saying, how does the state prove that something didn't happen, right? But in this case, I think it's a good, clear example, right? It favors Fish and says, hey, the state now has to show that his actions were not justified.
Yeah, and I guess I would say it doesn't really make them prove a negative as far as what factually happened or didn't happen.
Sure.
Changing it to say they have to prove that the actions he took were not justified. And there's a difference there, right? You don't have to say that something didn't happen. You have to say that here's what happened, and it's my job to prove that it wasn't justified instead of putting that on the defendant.
And how do you do that in a case where there are no other witnesses?
It's interesting because I think it's still the same strategy. It's just that I think your facts have to be better,
Okay, and that is an interesting point, right? If the prosecutor looking at this under this new version of this statute with this lens now, do you charge this case? Do you move forward with it?
Well,
you don't have anybody who can testify on that trail but Fish. And now, Fish is presumed to have acted in self-defense. Tough case. The prosecutor didn't retry the case.
Yeah, and the difference, I guess, would have been that they now have to give the instruction that the defense asked for, which is a little complicated.
Right. So on retrial, a couple of things. On retrial, they would have had to introduce specific acts of misconduct or violent behavior by the victim. The instruction would have been different. The Court of Appeals, in a parallel but unpublished opinion, touched on the other 20-something issues. A few of those issues that included, mental health records and other challenges that Fish raised. The Court of Appeals didn't say that those were big enough for reversal, but it did caution the trial judge to say, you might want to reconsider these rulings as well. So this trial judge kind of got hammered in that the Court of Appeals found a number of things that should be done differently. And so put my prosecutor hat on. I get this now case back from the Court of Appeals, and it's kind of a mess. It's a big mess. And you have a fairly sympathetic defendant, right? And people rallied behind Fish in his case.
I think that's important too, right? Is that maybe it would have been more difficult to get a jury that hasn't heard of this case at that point. It made national news at that point, and he had a lot of support. And so now, and I don't know if this is true, I saw some indications that some people believed that there was an election coming up and the Coconino County attorney was looking for strike their name. Maybe that's not a winning issue anymore for them to try to convict a guy that everybody likes and that everybody thinks was acting in self-defense.
That's right. So I suppose the political decision, the in-house decision was made by the Coconino County attorney. We're not going to retry Fish. His case stands. It was reversed. He's set free. Tragically, though, he died not too much longer than that.
A couple of years later, I think.
Yeah, had cancer and passed away. Yeah. This has become now a really kind of stark self-defense, Second Amendment, pro-Second Amendment case in Arizona, which is a very gun-friendly state. And I think it's something now, the facts resonate with a lot of gun owners and people who carry firearms.
Yeah.
Agree?
Yeah, absolutely.
And so Fish, I think, has become sort of a champion for what that means in self-defense, even though his road was, really difficult. I mean, this would have been, it took a long time from the time it happened to the time that the event happened to the time that he's convicted. He served several years
2 or 3
prison.
years, which, in the grand scheme of things, as defense attorneys, we might say, hey, that's pretty quick for an overturned case, and to have him released. Easy for us to say. I mean, what was he, 60 years old, spending 2 or 3 years in prison, wrongfully convicted. It's
right. So it took a chunk of his life away. It cost him who knows how much,
I've heard
for trial.
$100,000 was an estimate that I heard at one point.
Tons, right? Lots of money, lots of time, ultimately to be set free and then, later pass away. But I think this case stands as one of the important pillars in Arizona law, a changing point, to be sure, especially as it relates to the self-defense laws that we've covered. This case really prompted that change in the legislature. That, among other things, I don't think it was the only thing that made that happen, but certainly one of the many catalysts to say, hey, that burden needs to shift. And now as a defense lawyer, I look at the current self-defense laws in Arizona, and I think we're in a better spot.
Oh.
You agree?
Oh, it's such a huge difference. As we said, I mean, it's interesting how the jury is instructed and how the burden of proof works really can make the difference on whether a case is charged, but certainly whether a jury convicts.
Yeah, and understand that self-defense does not just apply in, gun cases and murder cases. It can apply in any sort of situation where there's any sort of threat of physical violence or even disorderly conduct or other things that are alleged. Now the state has to show that, beyond a reasonable doubt that it was not justified.
Yeah, and now at the same time, people need to be careful. I mean, we have a lot of people who come to us and really feel that they were acting in self-defense. And if you look at the self-defense statute in Arizona, there's things that kick you out, basically, of being able to use that defense or for the state to be able to assert it against you. Certain things like you can't instigate in an incident and then act like you were acting in self-defense, or
right.
You can't assault a police officer and say that you're acting in self-defense while they're trying to do a lawful arrest. There's things that happen that you have to. There's a lot of things still that make a self-defense argument. It has to be legitimate, but also you have to have acted appropriately. And
agreed. So this isn't just sort of a carte blanche, hey, we can do whatever we want and later claim that, self-defense.
Right.
You can't do that. You still have to follow the law. And, and we've seen a lot of these cases. Anytime a gun is used or other dangerous instrument, deadly weapon is used, and somebody's hurt, especially significantly, or somebody dies, very, very strict scrutiny is applied to those cases. You're going to have a police investigation. You're going to have prosecutors looking at this, trying to decide whether to prosecute it. And so the message is, yes, the law favors the defendant in a self-defense case now. However, you have to be very careful, because I think sometimes people fall into the trap of thinking that their conduct is justified when in fact it may not be.
Legally.
Right.
Yeah.
Okay. Well, that's State versus Fish. I hope that analysis was complete. I'm sure there's lots of other questions that people may have. But again, an important case in Arizona and another good discussion.
Absolutely.
So, thanks, Ryan. Appreciate it.